as 10 on mine. Is Ms. Robinson and Mr. Baldwin here, both?
Yes, sir.
Okay, let's go ahead and begin then. All right, you may begin.
May it please the Court, my name is Janet Robinson, and I'm the appellant in 5D10-2645. I'd like to reserve 5 minutes for rebuttal.
All right.
In addition to this appeal, there remains before this Court a 57-105 motion and an issue of contempt of the stay for which sanctions against the attorney and respondent and disgorgement have been requested of this Honorable Court. And an evidentiary hearing was held on those issues, and a subsequent sale occurred nevertheless. I respectfully request that this Court reverse the lower court's decision for 2 reasons. It's contrary to the law, and it was an abuse of discretion in many of the determinations. First, it was an error for the recused judge to enter 2 factually detailed orders while there was a motion to recuse pending. Second, there were
He had made the oral ruling prior to the motion, though, did he not?
She did make an oral ruling prior,
Right.
but the hearing that was held on the 21st, which was after the motion for recusal was served on the judge. That hearing was because there were some factual issues within that order that was proposed by opposing counsel that didn't comport with what we believe happened in that hearing.
I see what you're saying. Okay.
And so we had a hearing on the entry of the order. And then second, there were a number of issues, a number of errors, any one of which would have required reversal on the face of the judgment. And then lastly, it was an error to deny any kind of temporary support or fees during the pendency of the divorce because there was a well-established issue of a discrepancy in the income of the 2 parties. Your Honors, this case is about abuse of discretion, with Kanakaris being the seminal case. In this case, the actions were clearly error under the law and an abuse of discretion on the facts. Therefore, the propriety of the actions aren't something that I believe reasonable men could differ. This case actually is very much like Kanakaris. There was a great disparity of income between the 2 parties. The parties accumulated most of their wealth during the marriage. They had a number of properties, and even to the point that the former husband in Kanakaris purchased a house while the case was pending. Given the striking similarities, one would expect the results would have paralleled Kanakaris, where it was up before the court over an issue on whether or not the alimony was an abuse of discretion. And in that case, the court determined that there was no abuse of discretion with the alimony award. Here, the fact that there is no similarities, it did not parallel Kanakaris, would indicate an abuse of discretion. This brings me to my first issue, which is that it was error for the recused judge to enter the orders. At the beginning of the July 21st, 2009 hearing, my attorney pointed out to the judge that there was a pending motion to recuse early on when the hearing started. And she responded, "You know, technically you have a motion that's correct, and the court will have to recuse itself." She then went on to say that it was her understanding there had been a recent change in legislation, and as a result of that change, she had to be personally served. And so although she had the recusal motion, she agreed it was factually sound, she was not going to consider it served on her properly until it was personally served. We had, as I understood it, we had followed the Florida Rule of Civil Procedure, which we had served it on the court. We had given it to opposing counsel, and it was hand-delivered to the box outside of the judicial chambers where it says to drop things for judges. So that's how it had been served. Nonetheless, the judge did go forward with that hearing. And at the
I don't remember this. Is the method that you used to serve the judge in the record?
Yes. It is, Your Honor. And the judge referred during the start of that hearing on the 21st that she was relying on an email she'd received. It wasn't clear who the email came from. I'm assuming it was a clerk in the court, but it's really not clear. But she said she had received an email referencing Fisher v. Nuck. And based on that, she was taking the position that this was a ministerial order. She could enter it regardless of a recusal motion. And we continued to have that hearing. And as I said, the order was then ultimately, the order that was written by opposing counsel, a couple changes were made to it, and it was entered that day. July 31st, at the end of that hearing on July 21st, my attorney did return to the judge's courtroom with a copy of the recusal motion and personally serve her.
Yes, with respect to the October 6th order on case status, are there any items in there that you think don't accurately reflect the judge's rulings before the recusal motion was filed?
Yes, Your Honor.
And what are those?
There's some discrepancies on what date was being used specifically. It was difficult to recall. She held a case status conference on July 31st. It was noticed as a motion for temporary support, and she wanted us to hone down on what the decisions were. But there was an issue particularly on the date that was being used for the marital liabilities, which is not clear in that order. There was still the remaining issue of the $15,400 check that was written associated with the question of whether that land was marital
in general,
or not.
as I reviewed it, she said, I ruled on this, I ruled on this, I ruled on this, these were my decisions, and I couldn't find any of those memorializations that looked different from the oral rulings, which were mainly agreements between the parties. Okay, you agree that this is worth this is worth this. I mean, it seemed to accurately reflect what happened before a motion to recuse was filed.
The ruling, her case management order was very general, and the problem was I'm not sure that there were date issues in that case management order that were not clear. The date of separation, in fact, we ended up having another hearing on even that order, or actually a dispute. It was a paper dispute we proposed an order or we proposed some changes to that order. But there was a date dispute with what date the liabilities went back to, and honestly, I can't look today at that spreadsheet and tell you where the balances on the different mortgages, what date that ties to, because it wasn't clear, and it really isn't clear on the record what date the judge chose for those issues. The order on case management, specifically, I guess the issue is that order, even if it paralleled a lot of the decisions the judge made, the judge could not recall on her own what decisions those were. And because there was a pending recusal motion before her, it was inappropriate for her to hold. She's not supposed to continue to rule on that case.
The record reflects that she made notes on things and why do you say she couldn't remember the things that are reflected in that case management or status order?
Because the judge went back. We had a discussion about the date, the March, and there's in that hearing, in the minutes from that hearing, you'll see, or in the transcript from that hearing, there were some discussions, for instance, on the date of March 31st. There was a lot of time spent during trial on trying to establish bank accounts. And the judge had made a ruling using a date of March 31st, which was in fact the date that was the end of a quarter. The judge couldn't remember why she picked that date, but she thought maybe it was a date of separation, which it was not. So she concluded, I think it was the date, the end of a quarter. We had to remind the judge during that hearing about where those dates came from, and because that date was not clear, and it was specifically an issue throughout the case because we had not separated on March 31st. Our divorce was filed in July. The account that was assigned to me and the mutual funds and those things went into that account. When the judge chose March 31st as the split date for the account, it ended up assigning to me a great amount of funds that were then used for the next two months to pay all the marital debt. All of the marital debt was paid out of that Fairwinds account. So it was very important that the judge kept on track on the 331 because that date did not parallel a date of separation, a date of filing. It was strictly the end of a quarter. And in order to achieve equity, she had to allow me credit for the paying all of the marital bills out of those remaining funds for the next 2 months. That March 31st date became a big issue even in the case management, and I believe the case management order does not specify March 31st, but goes back to what Mr. Baldwin kept referring to it as the date of separation, which it was not. She also was not specific, obviously, in her instructions about during trial, the judge made a lot of rulings that aren't included in that case management. Most of that case management order is probably fine with the exception of the date. The issue is it leaves out a lot of other things that were decided during court, during trial, or were carried over into trial, particularly dissipation and marital misconduct that were postponed to be included with the later discussion on expenses. And because that case management order is not specific about that, the subsequent judge was convinced by opposing counsel it had already been dealt with, and it was not. Temporary support at the beginning of the case management hearing, the judge had said that temporary support would be something that could be dealt with by the subsequent judge. The subsequent judge took the position that it was already dealt with by the prior judge based on the issue on alimony. And also on the issue of alimony, the case management order says that the judge summarily denied alimony. It doesn't show the requisite findings that the court requires on the issue of alimony. To continue, there are a number of other math errors. Probably the biggest one, it deals with prestige construction and development, and that's also been the subject of the contempt issues before the court. Prestige construction development was my husband and I and another couple each owned a quarter of an LLC that purchased property and the intent was we would put money into the property and eventually sell it for a profit and split it. During the divorce, during the second day of, it was postponed from the first day of trial, and on January 5th, 2009, during the second day of trial, we again discussed prestige construction development, and the judge at that time, who was later recused, determined that, or we agreed to continue to maintain our portions of prestige construction development. It was going to be the only thing we would continue past the divorce. And based on that agreement, it was removed from the spreadsheet that the judge was using, the values for both. We didn't do any further discussion about the liability or values because it was a non-issue. It was going to be removed from distribution by the court. Likewise, the liabilities, the judge instructed us if we were asking the court to be repaid for the amount we were paying for the mortgage payments, that also needed to be taken off because it was equal. It was the same. So that's what we did, and the court's minutes reflect that. However, in the day of trial in front of Judge Roach assigned my interest to prestige construction and development over to my husband as an equalizing payment after the separation of liabilities. And when she did that, she pulled in my 25%. So essentially, my former husband's 25% was never allocated during the marriage, only mine. It adds and it's $190,000 or $109,000 difference. That was pointed out to the courts subsequently on a hearing on the entry of the order. Opposing counsel was told to check it out and see if maybe that's right, and that was never changed. So that remains an issue on that final order. Also, the liabilities, in this case, it was clear to the court, the evidence showed that there was this huge disparity of income. I was unemployed. I had been working for the family business, so of course when the divorce started shortly after that, I had no job. I was going to school trying to finish my degree. I was working what jobs I could find, but there was very little income. On the other side, my husband was working full-time, or had been, and certainly his income was greater than mine. Despite the fact that the evidence showed that, when the marital liabilities were split, I had requested, number one, I had requested that the marital dissipation throughout the case, from the very beginning, we had pled marital dissipation and marital misconduct. The judge ruled that none of that would come in. Okay. And then in addition, I was charged with half of the marital liabilities, which, and this is where there's absolutely no similar amount of income, but I was responsible for half the liabilities. The other issues were, again, we hit on dissipation, and then the temporary support also goes to those same things. Thank you.
All right, thank you, Ms. Robinson. We'll hear now from the appellee.
Your Honor, my name is John Baldwin. I'm here on behalf of the appellee. And throughout this case, in the appeal, I've had to deal with matters that are not properly, in my judgment, before the court, that is, non-record activities and non-record allegations of fact. That how do you confront that? It's very difficult to respond to that. And I've faced that throughout the case, and I've faced it today.
Well, let me ask you, do you have a copy of the second final judgment in front of you?
Yes, sir.
You go to pages 6 and 7.
Excuse me. Second final judgment.
Right, pages 6 and 7.
Yes, sir.
Okay, and this was an issue Mrs. Robinson just mentioned in her argument. It's in her brief, and I did not find any response to it in the answer brief. But the way I read what Judge Roach's mathematical calculations here is, originally when she finished the first trial, your client had in his column a net of $466,000. That's paragraph 3 on page 6.
Yes, sir.
And that the former wife had $453,000.
Yes.
All right, and that's top of page 7 there. And then she made 2 adjustments. She said $79,000 was put in his column, which it shouldn't because it was non-marital, so she deducted the $79,000.
Yes, sir.
And then she said they're both entitled to credits for payments on marital liabilities. He paid $84,921 more, so I'm going to deduct that from his column. All right. So as a result, she gets to the top of page 7, having made those 2 adjustments in your client's favor.
No, oh, you're reading, I'm sorry. I was looking at the second judgment. Okay, I'm sorry. I'm now reading.
Second final judgment, page 6 and 7.
Yes.
All right, so if you go to the very top of page 7,
Yes.
Judge Roach then says, having made these adjustments,
I come up with these numbers.
they come up with these numbers, $302,849 for your client and $453,678. So
Yes,
right
sir.
now your client's behind.
Yes.
So she's got one more asset she's going to distribute.
Yes.
And so she's going to do the Prestige
Construction and development.
where she values it, the net of $218,000.
Yes.
A gross of $287,000, a liability of just under $69,000 and $218,000. Now, if you do the math, $302,000 plus $218,000 is $520,000. And so now your client's at $520,000, and the former wife is at $453,000. That's a significant discrepancy. And I think what happened, if you look at paragraph 5, is she took that liability off twice. She took the $68,000 liability and she credited it twice to your client instead of once, because if she'd only done it once, it'd come out almost exactly even, which seems to be the goal. So do you agree there's a math error there?
Yes.
Okay.
That was
The
easy
reason the
enough.
math error, okay. So,
I can even tell you the number.
all right.
The number would be that he would owe her $33,920.
Okay.
I agree with that. I agreed with it there.
Well, it's not, the final judgment came out, it's not agreed in your brief.
No,
You don't say they're entitled to that credit.
No, I didn't. I did not say so in my brief. But I agree with that number. There was a rehearing argument. I agreed there. But
Let me ask you about some,
if you're equalizing totally. Now, there can be, we're talking about $33,000 over $700,000 or $900,000.
well, if your client pays her $33,000 and if the judge's math is otherwise correct and the valuations are otherwise correct.
That would be 50/50.
That corrects
Precisely, yes.
Okay. Let me ask you about,
Did you pick up on where it was valued? I mean, they said it wasn't valued either.
yes.
It's amazing to me how appellate courts can read transcripts that to me.
No, it hasn't, in the original
First page.
column, there's no value given to Prestige.
No, but it's on the column on the right, and then at the beginning, you'll see where we stipulated to the agreement, to the value.
Right. I'm not disputing the value, just
Okay.
that there's a math error and it appears
Yes.
the liability was taken off twice instead of once. Let me ask you about these comments from a transcript, an argument regarding the motion for stay, or after our order stay. In this case, the 5th District ain't listening. Are you hearing me? You ain't listening to what the appellees say here. Consistently, every pleading we filed here has been ignored. We get mistreated, unbelievable. They don't follow the law. They don't look at the standards of the standard of review. They think it doesn't apply to them.
Judge.
Who made those comments?
I made those comments.
Okay.
Judge Evans commented on that, said, well, Judge Caney tried to take him on too. He didn't do so well at it, so you be careful. I did make those comments, and I'm prepared to back those comments up. There was the motion for the stay, and there was no record. And the standard on the motion for a stay that has been heard by the appellate, or by the trial court, and it's supposed to go to the trial court first, is abuse of discretion standard. That's a first DCA and a third DCA opinion. They didn't even file a motion in the appellate court for a stay. They filed a motion to review the trial court and attach the pro se motion of
Now, you realize the final judgment distributed real property, correct?
Yes, sir.
And you realize that there could be a challenge to the distribution of real property. And you realize that if there isn't a stay, then the court's ability to remedy an error, if there was one, is gone if there's no stay on the sale of real property.
I did not realize that.
You don't? Why not?
Because there's $600,000 in assets on both sides, and there's
Real property is unique, correct?
well, okay, yes, it is unique,
Yeah.
but that is
so
not
in other
where
words,
they
your
were going
statement
on
is
value.
incorrect. So
Yes.
your statement is incorrect. Let me ask you this.
May
on
I
a level of
comment back?
professionalism, on a scale of 1 to 10, with 1 being the lowest and 10 being the highest, where would you place your comments?
Sir, I felt proper. I felt that I'm right.
So you think these comments reflected a high degree of professionalism?
Sir, I disagreed with what the court did with this stay, and I went down this list on my motion, and there was no record before the court. None. You didn't consider the bond.
You can disagree with the court order. I'm asking you whether you believe your comments reflect a high level of professionalism.
I felt being professional does not mean that I can't take issue even with the appellate court.
I agree with that. That's why we're here. We're in appellate court. We hear nothing but
Right.
cases where someone
Right.
has taken issue with the trial court's decision.
When I filed my motion to vacate the stay, I appeared to have been totally ignored, and I gave a lot of reasons. There was no record before you. None. And your standard is abuse of discretion. There was no record.
And
None.
how would we remedy an erroneous distribution of real property if there wasn't a stay?
You set off. You set off.
Real property is unique.
Okay, well, what about the issue of a bond? My client was facing payments as it became...
Why does a
this is-
bond apply? Is it correct that it only applies where there's a money judgment?
No, it does not, and I gave you the case on that. And it's I believe it's your 5th District case that says to not set a bond is erroneous. And in this particular case, and that is, it's 3rd DCA, Makowski, okay, that does not say, the one provision of the rule specifically addresses money judgments. The next part of the rule addresses non-money judgments, and it does not say there has to be a bond. It's highly unusual not to have a bond. And when my client's in the posture of being a destitute construction worker and having to pay $1,700 a month, then she wants to preserve that, then she needs to be chipping in on the $1,700 a month, or in the alternative, post a bond. That's a very fundamental thing, but this court did not make an inquiry. The court did not make an inquiry of me on the motion. Now, maybe I should have filed a response on their motion to stay, but there was no record to support their motion for the stay, and it didn't happen until 6 months after they filed the
Let me
motion.
go back to my original question. On a level of professionalism, 1 to 10, where do you put your comments?
I'm happy with my comments, sir, and I have high regard for the bench, I have high regard for my profession, I have high regard for what I do, and I think there's times I have to stand up and say things that might not sit well with an appellate court, might not sit well with a trial judge. I know that, and I might get condemned for it, but I like the system I work in. I have no problem with the system I work in. But there's times when I felt like there's a standard.
Counsel, hold on.
Pardon?
You think that saying they don't follow the law, they don't look at the standard of review, they think it doesn't apply to them? Do you think that's a professional comment to make about
That's
an
not a
appellate
professional
court?
comment. That's not a professional
Well,
comment.
hell no, it's not.
No, it's not. Okay, can I point out some of the other factors on considering a bond that this court did not consider? Whether the grant of stay includes the moving party's likelihood of success on the merits and the likelihood of harm should the stay not be granted.
We're not saying that we never make legal errors. The Supreme Court reverses us. We're not saying trial judges never make legal errors. Sometimes we reverse them, and sometimes the Supreme Court changes. Sometimes they get reversed by the U.S. Supreme Court. Sometimes the U.S. Supreme Court reverses course. But that's not the issue here. The issue is the lack of professionalism in those comments.
All right, sir.
And what amazes me is that until Judge Monaco just followed up,
Until Judge what?
Until Judge Monaco just did his follow-up question, you were apparently unable to recognize the lack of professionalism in the comments, and that concerns me. I mean, I understand making the unprofessional, heated remark. I mean, that happens. People say something they don't mean to say. But for you to come in here and then say nothing wrong with them initially, I find that amazing.
I'm sorry. I'm sorry that you feel that way, but I filed a motion to vacate a stay, and I set forth a whole bunch of reasons why this court should address the stay issuance itself, and it was immediately denied. And I was not heard at all. And I gave you lots and lots of law that there were things to consider in issuing a stay that should be considered by the court, and it was not. And there was no record before the court. And how you have to show, they have to show to overturn the trial judge's denial of the stay. They have to show an abuse of discretion. And you had no record there at all, but you were listening to a sworn motion that was filed at the trial level by a pro se party, okay, bringing in matters that were not in part of the record in any event. And there was not even a motion sworn here. Then I have to say that is not following the law. That is my understanding of the law is you are in considering a stay, you are supposed to consider all of these other factors, and just the very part about the jurisdiction argument had to be considered whether it applied, and I asked for direction from the appellate court on that. That's another area. I asked for direction, saying, we have a parcel of properties owned by an LLC in Texas. It's not a party to this case. Are we bound by this stay? And I got to follow the stay. That's what I got. I did not get anything saying participating with me in that regard. And the way you talk to a court is by motions and filings, and I tried to act in sincere good faith and best efforts, trying to say, what am I supposed to do? I got back from vacation. I got a notice from something that said a stay had been entered. Much to my surprise, that was a Sunday evening, the way you can do it with emails now.
Let me ask you this. Ms. Robinson said that this math error was brought up, and Judge Roach asked you to check on it. And now you come here today and admit there was a math error. Of course,
There's a math error.
now it's been in the final judgment. It's been subject to briefing. You know, we've prepared it. Now for the first time you can see the math error.
No.
Is that a sincere best interest?
That is not accurate what you just said about me.
Well, is it in the final judgment?
It's in the final judgment.
Did you concede error in your brief?
No.
So when was the first time you let this court know that that was not an issue?
The way it's briefed does not say what you just calculated. That's not the way it's briefed. But I
Well, they
respond.
brief it. They say that the judge made an error in that, with regard to the prestige, that it left your client with a lot more money than their client. And you agree with that? Today, you didn't agree with it in the brief.
Well, I don't think that, first of all, I did not. I did not. I'm not going to dispute that. I'm just telling you that a $30,000 error on a distribution of $1.5 million or $1.25 million or something like that is not a significant error, and you may not. And I'll tell you that there were numerous things here where we were not treated fairly as well. The appraisal of the house was appraised multiple times to come to $515,000. She took the lowest appraisal, of course. Then there was the money issue about the money. She kept, at the beginning, you recall, I gather from what you've read, you're pretty close on it, the financial statement. She left nothing in her first financial statement, didn't give anything about all the money that was going through her account. Then when I tried to do discovery and say, give me, and she gave me this financial thing that you couldn't really read, and I said, give me the monthly statements, and they wouldn't give it to me. Same thing on the tax returns. The tax returns, she wouldn't give me the 2007 tax returns. Okay? The court can take those things into consideration and not consider those to be significant. Not consider the $30,000 to be significant. The court can consider that. She never even she went from lunch to get her 2007 tax return in 2009. And we'd been asking for it and couldn't get it. She gave a financial statement that left off the fact that she had $70,000 in the bank and was moving around and she was making deposits all over the place, and we still don't have one of the accounts. We never saw one of the accounts. Part of the 2007 tax return was that there was a Schedule E on deductions, and she was specifically asked about it before lunch, and she came back from lunch and said, oh, I forgot about that, and she didn't bring that Schedule E. I think it's D or E is schedule. It wasn't attached to the tax return. There was misconduct on the other opposing party. She was sanctioned repeatedly and told, you know, this is wrong. She brought in, she was taking these financial registers and deleting things so that you couldn't see where the money was flowing to. And I'd asked for the monthly bank statements. And then it became apparent. And the judge caught on to that. Judge Thorpe did at trial. Prior to trial, she did not. Okay, and made some adjustments there, and in my client's favor. The court did pick up on the appraisal that we agreed to the values. I wanted to make sure you knew that. There's another part that I want to make sure the court knows about. Throughout the appeal and throughout this case, I've had to deal with this March 3rd hearing. And I pointed out there's a local rule that they're supposed to have submitted the order. Well, there was, in the hearing of March 31st, or in the hearing, subsequent hearing, Mr. Weiss brought it up in 2009, a year later, and the judge specifically ordered him to prepare an order from that hearing. I did not know that, she said. Okay? And we did that. If you will prepare an order to complete the record, that will be fine. And that was on July 31, 2009, approximately 17 to 18 months after the hearing. Still no order was prepared. He was complaining about the order then. But throughout this case, and as a basis for the stay, she cited the misconduct that was heard at that hearing, and that isn't what the court didn't find misconduct there or anything wrong. She said it was paying the bills, and that's not a violation of the order, she said. That's why there was no order prepared, and that was when she had her first lawyer.
You challenged the trial court's finding that your client violated the stay order with regard to the sale of real property to his sister?
No, I did not. When I heard that, that was in that hearing, and what? one of those times when you sit there with what? Why didn't you tell me that?
Even if the corporation was permitted to sell property, do you believe your client's taking of $92,000 or $96,000 or whatever from the sale of the real property, do you believe that was a violation of the order of stay?
That was never, I don't know about that one. You can argue that in many ways. There was property left in the corporation at that point, so I don't know. But that, and again, they were saying you violated something by furnishing a copy of an order. I did a copy of a final judgment. I informed my client.
So that's their motion. That's not a court order.
What?
They moved to find you in contempt. There's no court order finding you in contempt. So the reason I asked about the sale to the sister by your client is did your client violate the stay order, and you acknowledge that he did?
Yes, on that, yes.
Okay.
And I can tell you, I don't know that there's no order. To say the anxiety in this case about sanctions on me for furnishing a copy of a final judgment, I mean, as soon as that sanctions things come in and saying, Baldwin, you violated the spirit of the final judgment. What did I do? I wasn't told what it was I did. Well, what you did was furnish a certified copy of the final judgment. When a client calls me about a final judgment, I'm going to furnish it to him. And I'm not in Texas, and I don't know Texas law, and I don't know anything about my involvement in that real estate transaction is minimal. He's in Texas. I'm in Florida. I'm a Florida lawyer. I don't know anything about Texas property.
Counsel, your time is up. Thank you.
You say my time's up?
Time's up.
Okay.
Ms. Robinson, you have 4.5 minutes.
Thank you. Thank you, Your Honors. What you were talking about with the motion for sanction is actually shows you a pattern of conduct that we dealt with throughout this case. At the beginning of the January 5th trial, there was a similar issue where Mr. Baldwin was not happy with the ruling of the trial court in a end of December hearing, and he, outside of the courtroom, threatened my attorney, who brought that up to court on January 5th when we returned to trial. Again, the judge requested that he apologize, and again, the same type of response. I didn't do anything wrong. I'm not going to apologize. There's nothing wrong with me doing that. I also think it's important to understand that in the arguments about the motion for contempt, Mr. Baldwin quoted case law, but he cherry-picked the case law. For instance, he used Assyrian and said it's true that the trial court has no power to enter a transfer without a joinder of a corporation. He talked a lot about that. If you read beyond the next sentence in Assyrian, it says, nevertheless, even when the corporation is not a party to the dissolution, the trial court can award the wife a special equity in the husband's interest. It further says, lack of jurisdiction over the corporation would not prevent the trial court from awarding the wife the husband's interest if justified, and it may preclude the husband's disposal of assets over which he exercises control without joining the corporation. And clearly, my former husband was controlling a lot of what was going on with those things. Also, on the contempt issue that he brought up just now, the trial court records show that the minutes from the trial court show that he was found in contempt. We walked out of that courtroom, and a week later, Mr. Baldwin wrote a letter to the same gentleman that had written the $74,000 check that my husband had taken that should have been shared with me, and said, the wife did not win in this hearing. You can continue to do things the way you were doing. My attorney had to interject. Early in the case with my first attorney, she had to write letters to Mr. Baldwin. They're also on the record, reminding him that you can't dissipate the assets, reminding him that there was a standing order. This has been a difficult case. Mr. Baldwin talks about me crossing things out and not providing bank accounts. There were situations where issues were raised during court. We wanted this case over with. It wasn't my desire to end up in appeal. I wanted to see us wrap this up. This has been very difficult financially for me. But in the case of the bank statements, he continued to say I wasn't providing statements. We did banking online. I was providing the online bank accounts. I did redact the account numbers only, and had he at any point asked for the account numbers to not be redacted, and that's what he was asking for, I would have provided them. But he kept saying he wanted the bank statements that come from the bank, which I didn't normally get. He was provided all of the accounts, and there was no difference between what I provided previously and what he got from Fairwinds, other than the fact that it came directly from Fairwinds. In fact, the Fairwinds one excluded one of the accounts I had previously provided. And wrap up, the respondent's case is based on personal attacks, the wife's chicanery, and rather than the legal arguments on this case. Clearly, I was in a situation where I made considerably less money. I did not have the financial resources to fight this case. I ended up having to finish trial without an attorney, and now I'm having to finish my appeal without an attorney. A lot of this is due to the motions and the actions of the other side. The order on case management should never have been entered once that judge was recused, and unfortunately, the subsequent judge based everything off of representations by Mr. Baldwin in court as to things that happened in front of Judge Thorpe. And because the judge didn't review transcripts of those hearings, it put me in a position where she wouldn't let me inject evidence during that final hearing. There were a number of times that the judge just said, no, I'm not going to hear that. Mr. Baldwin says it was heard. I'm not going to hear that. This case was an abuse of discretion,
Counsel,
and I ask that it be
your time is up.
remanded. Thank you. Thank you very much, Your Honors.
All right.